Okay, good morning, ladies, once more. We will follow with a session about trademarks and designs. And my name is Liberte, and I'm moderator of this session. I am a head of trademark and industrial designs department in the patent office. And this actually is the reason why I am also moderating this session. Actually, this session was subject to change all the time since we prepared our conference. And as you see, still one person is missing, but we hope that he will join us. And also you see some other persons as you see in your agenda, but we wish Mr. Christoph Ernst good health and to be back on a track as soon as possible. The first presentation will be given in this session by Mr. Archambeau, and he currently is the Vice President of the OHIM, of the Office for Harmonization in the Internal Markets, for trademarks and designs. Before joining this European agency, he dedicated 8 years to managing the administration and the human resources in the European Patent Office in the Netherlands, where he worked since 2002. Mr. Archambeau's European Union working perspective also comes from 15 years working in the European Space Agency, where he held various managerial positions since 1987. The topic Mr. Archambeau will speak about is the European Trademark and Design Network. And as we know, community trademark exists parallel to national trademarks, or we could say in another way, national trademarks exist parallelly to community trademarks. And actually the aim of both systems is to satisfy needs of all companies, big companies, multinational companies, and also of small and medium-sized companies. And without network between both of those systems, without network between European Agency, Office for Harmonization, and the internal market and national offices, it seems not to be possible. And I give the floor now to Mr. Archambeau.
Thank you. Dear Director of the Patent Office of the Republic of Latvia, Sandris, he's not here, but he's, I suppose, flying around all the different meetings and obligations of the presidency. Ladies and gentlemen, dear colleagues, I would first of all congratulate Latvia on the presidency of the Council of the European Union and say what an honor it is to be here in Riga. It is my first time in Riga. To address such a wide spectrum of government, industry, and of course the intellectual property sector. Today's event, in which I am happy to be joined by so many colleagues from the IP offices from the European Union, WIPO and the European Commission, focuses on intellectual property and beyond. This title captures very well the idea that IP is not just a thing in itself, it has to serve a purpose. Our speakers this morning have explained the relationship between intellectual property, the economy, society, and the European Union. My address today deals with the role of the European Trademark and Design Network in this constellation. Before dealing with the challenges facing the network for the future, I think it is useful to provide a little context of where we are today and where we come from. This is especially true as we are going, like Professor Gurry said, through a period of considerable change. As you may know, OHIM was set up just over 20 years ago to administer the community trademark. Today, OHIM also administers community design rights and since 2012 has been entrusted with the European Observatory on Infringement of Intellectual Property Rights. We know from a major study published by the Observatory how important IP intensive industries are to jobs, GDP, and trade in the European Union. The study found that the IPR-intensive industry support directly or indirectly 35% of jobs, almost 39% of the EU GDP, and 90% of the EU external trade. So these are facts and figures. You know, you always talk about concepts and about ideas about how intellectual property helps. I mean, these are real figures directly linked to the economy. A second observatory study has shown that there is a sizable gap between the facts and evidence on the one side and the perception of the citizen in general, and in particular from the younger generations. While 96% of citizens say that they support innovation and creativity, and 7 out of 10 people say that IP companies contribute to more jobs and growth, a significant proportion of the population is prepared to support buying counterfeit products or illegal downloading of files under certain circumstances. Among young Latvians, for example, 77% of 15 to 24 years old consider that it's acceptable to download copyrighted protected material as long as it is for personal use. More studies are underway or planned, including the revision of studies we have already made, and including a number that will address now the economic cost of IPR infringement, but there is still a lot more to learn. The community trademark and designs administered by OHIM are a core IP right and a major business asset. But in today's business environment, they only form part of a basket of IP rights, which Latvian, European, and global businesses use to protect innovation and creativity. It is important that these rights are administered in an efficient and effective manner and that they are accessible. But it is equally important that they are properly enforced. As mentioned earlier, right now we are going through a period of change. IP professionals, businesses, policymakers, and other stakeholders need to take account of this and, wherever possible, contribute to the debate. This brings us to the heart of the question: what kind of trademark or indeed IP system do we need for the future? In answering this question, we must take into account the fact that we are dealing with a two-tier system with regards to trademark, for example. The system, which has national rights, such as those administered by the Latvian office, and the EU-level rights administered by OHIM. In the patent area, there will also soon be the unitary patent administered by the European Patent Office. In order to make these two-tier systems work well, it is vitally important that there is a good cooperation among all the various IP actors and the stakeholders, including the users. The European Trademark and Design Network, in which the Latvian IP Office has been an exemplary active partner, was brought into being to achieve this goal and was one of the main 2 pillars of OHIM's current strategic plan. Looking at OHIM alone, there are presently 950,000 trademarks on the register and almost 800,000 designs. To this, you must add all the rights registered in national offices. Looking just at trademarks, by now, around 11 million trademark rights are on the various EU registers. In order to allow quality IP rights to be granted that can be protected, it is of course vital that we know what right exists in the system. Consequently, a 21st century IP system needs to be built on interoperable databases with state-of-the-art search engines. This is the reason why tools like TMView and the WIPO Global Brand Database have been developed. TMView is just one of the 19 IT projects that have been developed under the umbrella of the European Trademark and Design Networks in the past 4 years. The network has been extremely successful in bringing together all EU IP offices and major users associations to build a common IT tools that to converge in practice. The tools offer resources which can be used by the public, by representatives, by offices alike, and also resources that are used by IP offices internally to increase their efficiency. They cover e-filing, e-services, back-office file handling, quality, e-learning, and many other matters, including important open access databases that are free to everyone on the internet. The TMView database, for example, provides free access to trademarks information from 47 different offices, including all EU offices. Last year, it delivered on its own 5 million free searches over the internet. It contains over 24 million trademarks in 34 different languages, and that includes all EU languages. All these tools are an investment in the future of the EU trademark and design system. They are making it more transparent, interoperable, efficient, and user-friendly. This value is reflected by the enthusiasm shown by national offices for adopting and using the tools. And here I must say that the Latvian IP office has been one of the most supportive partners in the network. To date, we have more than 315 individual implementations of tools having taken place, over a target of a maximum of 350. This is an average of 14 tools implemented in each office. In the case of the Latvian office, 17 have been implemented and another 2 are well on the way. While shared state-of-the-art tools are very important for a properly functioning IP system, this is not enough on its own. The second element needed for an IP system that relies on different offices is that there also needs to be convergence in the processes and the practices. Another thing that was mentioned as a priority by WIPO. The convergence program runs under the European Trademark and Design Network and has made significant progress in reaching agreement on trademark classifications and a number of other areas. Once again here, the Latvian IP office has been a huge supporter of the convergence program and is taking part in all 7 projects. The work of the European Trademark and Design Network is already making a significant contribution to transparency and efficiency amongst EU offices, and most importantly, is a major driver in producing increases in quality in the rights granted. Ladies and gentlemen, users need high-quality rights, whether they are design, trademarks, patents, or other type of rights. Quality can be defined in a number of specific measurable issues, such as timeliness of a decision, the quality of the drafting, the consistency of the decision-making, and the predictability of the decision. Looking at the situation of OHIM with regards to timeliness, since 2010, the average time required to register a community trademark has fallen from 6.3 months down to 5 months. That is a 25% improvement. However, greater speed must be accompanied by decisions that are drafted well, and here there are also progress that has been made. Over the past few years, the ex-post quality checks at OHIM have been extended to cover all operational areas. At present, the office is performing well in most of the area, including CTM examinations and proceedings, absolute grounds decision, opposition decisions, oppositions proceeding, cancellation proceedings and decisions, and RCD publications. Now that the ex-post quality checks cover all operational area, the focus will be to move towards ex-ante checks. Let's do the right thing first. We will also increase the involvement of the users to make sure that the checks are better aligned with the quality that they expect. The office reorganization in October last year includes an increased focus on users, and that plays a central role in the way forward. All examination tasks, including registration, are being progressively concentrated in the operations department, and a customer service department has been created as well. The new structure has a greater emphasis on team working with horizontal responsibility and a matrix structure to ensure an integrated approach to users. We are moving towards having teams specializing in dealing with different types of users. Within the operations department, for example, there will be 3 clusters specializing in our key users, other representatives, and SMEs. The customer service department will also engage structurally all 3 customer segments, and in parallel will continue to work with our 250 largest users under the key user program to ensure that they can take full advantage of the tools for e-business and e-communication that we now have available. At present, more than 180 of those 250 largest users have signed protocols with the Office to prioritize the use of electronic tools, and we are working to increase this, hopefully extend it to 250 and beyond. This approach will ensure that before entering the examination process, users will receive a high level of support, including better access to pre-validation and to the tools and databases that will help them predict the outcome of their filing decisions. The end result for us will be higher quality applications. Good drafting based on published guidelines using well-crafted templates and accompanied by comprehensive checks will also result in more consistent decision-making. The new OHIM guidelines, which now form the single regularly updated guide to examination decision-making, are a significant achievement of our knowledge circles, which bring staff from all departments together to work on common issue. The guidelines are also a huge success in terms of involving the national offices and the users in the ongoing revision cycle, and I would like to warmly thank everyone that has participated to this process. To give just one example, one of the main achievements of the Convergence Programme is the progress made on the harmonization of classifications and the continuous growth of the harmonized database of goods and services. This work is carried into practice via the TM class tool, which now has 41 national and regional IP offices within it. Searching is available on pre-validated terms in 31 languages. The Latvian office was one of the earlier offices to join and has been fully harmonized since November 2013. And since last month, we now have all EU national offices incorporated in the tool. Since 24 November, the office has also introduced a new fast-track e-filing process for trademarks. This process is available to those applicants who opt to select the goods and services from the harmonized database and agree to pay at the time of filing. As mentioned earlier, the standard track for CTM is already gone down from 6.3 months to 5 months. Well, if you use the fast-track procedures, you will get your registration in under 4 months. Of course, you need to have some straightforward criteria to be fulfilled in order to reach this. But there is clearly user demand for this service. Our latest figures show that around 25% of all applications are using the fast-track procedure, which is well ahead of our initial expectations. To give you an idea of the magnitude of what we're talking about, 38% of users are already taking all their terms from the harmonized database. This means that the terms are pre-validated and already translated. In concrete terms, using this harmonized database is speeding up the system, reducing the cost, and helping many thousands of applicants to avoid the delay and other problems associated with classification issue. Ladies and gentlemen, I mentioned earlier that the European Trademark and Design Network was a key element of OHIM's current strategic plan. We are now in the final year of the first cycle, 2011-2015. Overall, at the end of last year, the strategic plan was 91% complete. Of the 100 projects launched under this plan, the majority have been finished or are at an advanced stage. In this framework, OHIM and the national offices of member states have developed the concept of a fully fledged and functioning European trademark and design network to promote a more efficient European IP system for users. The projects which have been carried out represent an investment of 76 million. This was made possible by some of the reserves that OHIM had accumulated in the past. On the whole, they are now fully operational and are providing the European industry with substantial gains. OHIM has already completed the consultation process and has begun the preparation for the next 5 years. The goal is to ensure that the project of the current strategic plan and the office activities are continued for the benefits of users and member states, as well as looking forward to 2020 and developing new projects for users. In this regard, it will be important to ensure in the future that the Office possesses the necessary means to maintain and further develop the European Trademark and Design Network together with national offices for the benefit of users. Sorry. Allow me to say, however, that from our perspective, it appears that the negotiation process on the trademark package has reached a stage where the sharing out of OHIM surplus seems to become the main issue to the detriment of the objectives of harmonization between member states, which should remain a priority for the internal market and the users. The predominance of a purely financial objective could lead to OHIM being contained within its operational budget, thereby challenge the continuity of the strategic actions we have taken so far. The provision being discussed seemed to result in a 20% reduction in income, a 15% increase in expenditure for various provisions, and the possible transfer of surpluses. The combined effect of all these measures is not compatible with the Office obligation to present balanced budget before 2021. Without the necessary resources to bridge this 5-year period, such a scenario would require a significant reduction of 25% of resources dedicated to cooperation, for example. It would also require a reduction of the Office running expenditure of 15% and would put into question the affordability of a next strategic plan. In addition, it must be noted that these predictions are based on a historical growth of 5% of applications per year, a situation that we had not seen since 2012. Over the last 2.5 years, growth has been limited to 3%, and this year, admittedly early days yet, we won't even reach that. Of course, OHIM will implement the results of the legal reform decided by the Commission, the Council and Parliament. However, it is important to bear in mind at this stage that if the necessary means to sustain the current trademark and design network are to be diverted, OHIM will not be in a position to commit to the implementation of a second strategic plan and continue to develop the type of important actions for users in the European trademark and design network that have shown such success in the past 4 years. Ladies and gentlemen, we are rising to the challenge of embracing the change in IP, and this is quite rightly one of the priorities of the new European Commission. There is now a very active discussion on IP rights in the EU at political level. Amid all these changes, it is important that Europe continues to work for cooperation and convergence that has been demonstrated to work so well within the European Trademark and Design Network. For the future, this work must increasingly include global partners in order to influence how the intellectual property system as a whole evolves. This is the reason why OHIM is acting as the implementing agency for a number of important EU-funded programs on IP in China, Russia, the 10 ASEAN countries. Indeed, this month we are starting the inception phase of an important program in India as well. Having shown by example that cooperation and conversion is both possible and successful within the EU, it is clear that other offices are interested to join. This is an area in which we need to be as ambitious as possible. The European Trademark and Design Network has delivered great benefits for the users and the national offices. This has been made possible by reinvesting gradually the surpluses accumulated in previous year in the trademark and design system. So far, half of that surplus has been used for the benefit of the users of the system. There is more work to be done. We also need to make sure that other stakeholders, such as small businesses, ordinary citizens, and young people, are brought on board, since in the final analysis, IP rights need to be understood, accepted, and supported in order to deliver the things that really matter to citizens: economic growth, job, and social well-being. Thank you very much.
I would like to thank Mr. Archambeau for sharing with us successful story of Office for Harmonization in the Internal Market. And of course, I share his opinions that users need high quality rights and must get it quickly in a reasonably short time. At the end of the session, we will have a questions and answers session. and everybody will be invited to ask questions if somebody has. The next speaker in our session is Dr. Roland Knaak. He's attorney at law in Munich, Germany, and head of unit at the Max Planck Institute for Intellectual Property and Competition Law. After his studies at universities in Mainz and Munich, his doctoral thesis at the University of Munich, he became a researcher at the former Max Planck Institute for Foreign and International Patent, Copyright and Competition Law in Munich. In 1986, he was admitted to the attorney's bar of Munich, and since 1987, he is practicing in the law firm Knaak and Lechtleitner in München. Since 1999, he is a lecturer in European Trademark Law and European Unfair Competition Law at the University in Zurich. And in 2002, he became president of the German Institute for Geographical Indications. Dr. Roland Knaak is an author of numerous publications in intellectual property law, mainly focusing on the field of national, international, and European trademark and unfair competition law, and the law on geographical indications. And now the most important part, he was member of the team of the Max Planck Institute that conducted the study on the overall functioning of the European trademark law on behalf of the European Commission in 2010. And actually this was the reason why we asked him to come to Riga to our conference and give a presentation about trademark reform. And actually the title is, Does the Trademark Reform Meet Expectations? Okay, please, the floor is yours.
Thank you, Mrs. Liberte, for this warm welcome. I'm honored, of course, to be able to speak here on the trademark reform, the ongoing disputes and negotiations on that reform. The title of the presentation is, Does the Trademark Reform Meet Expectations? And this requires a pre-question, what are or what were the expectations in that reform? Let us go back to the beginning of the reform process. The political process began in May 2007 with the Council conclusions regarding the financial perspectives of the OHIM and the further development of the community trademark system. These conclusions were a reaction to the increasing surplus in OHIM's budget and the decreasing number of national trademarks in the member states. These conclusions emphasized as main features of the CTM system, first, a balanced OHIM budget, and second, the coexistence between the community trademark system and the national systems. And these conclusions suggested more cooperation between the OHIM and the national offices. In order to achieve a balanced OHIM budget, the conclusions called on the Commission to propose as a first step a reduction of the OHIM fees. This fee reduction was implemented in 2009 by Commission Regulation number 355/2009. In order to assess the coexistence, the Council called on the Commission to start work on a comprehensive study on the overall functioning of the CTM system. This study was carried out by the Max Planck Institute in Munich in 2010 and published by the Commission in 2011, in February of 2011. The next step in the political process was the Council conclusions of May 2010. They changed the wording from a reform of the CTM system to a revision of the trademark system in the European Union. And they summarized as main objectives of the reform 5 measures. First, a legal framework for cooperation between OHIM and the national offices. Second, a legal basis for the involvement of the OHIM in enforcement-related activities. Third, a legal basis for distributing 50% of OHIM's renewal fees to the national offices. Fourth, amendments that support the coexistence between the community and the national trademark systems. And finally, measures to make the directive more consistent with the regulation. In other words, more harmonization of national trademark law. It was clear at this point of time that the trademark reform should not be confined to the community trademark system, but cover the national systems as well. These were the expectations in the trademark reform in 2010. Are these expectations met by the reform? Just a few words to the state of play of the reform process. The European Commission published the proposals for an amendment of the regulation on the community trademark and for a new trademark directive in March 2013. In the European Parliament, the Committee on Legal Affairs, chaired by Cecilia Wikström from Sweden, drafted a report with amendments to the Commission's proposals that was submitted to the Parliament in January 2014. In the plenary session of 25 February 2014, the Parliament adopted most parts of this report as its position at first reading. The Council discussed the Commission's proposals in the Working Party on intellectual property as of April 2013. A compromise proposal of the Council Presidency with amendments to the Commission's proposals was adopted by the Committee of Permanent Representatives in its meeting of 23 July last year as the Council's common position. The Italian presidency of the Council was mandated to enter into negotiations with the European Parliament in order to achieve an agreement on the reform. Since October last year, the European Parliament and the Council are working on the final text. An agreement on most issues has been reached, according to a joint statement published by the negotiating team of the European Parliament and the Italian Presidency of the Council last December. Even the debated transit issue is resolved. There remain some other issues which are still under discussion, among them obviously the cooperation scheme and the financial support of the national offices by OHIM. To what extent will the trademark reform achieve the reform objectives as defined by the conclusions of May 2010? First, cooperation. The cooperation scheme is already working and functioning well, as we have just heard. The reform will establish the legal framework for this cooperation in Article 123C of the regulation. This provision will be added by provisions in the directive that define the role of the national offices in that cooperation. The main difference between the Parliament and the Council regarding cooperation relates to the question whether this cooperation should be binding or optional. The European Parliament voted for a binding cooperation rule in the directive. The Council has proposed a provision for an optional cooperation. This issue appears still to be under discussion. Next point, involvement of OHIM in enforcement-related activities. A legal basis for the involvement of the OHIM in these activities does already exist by Regulation number 386, 2012, on entrusting the OHIM with tasks related to the enforcement of intellectual property rights. In the regulation on the community trademark, the tasks referred to in this regulation will explicitly be enumerated as tasks of OHIM. Next point, financial support of the national offices. Provisions that stipulate the financial support of the national offices by OHIM will be implemented into the regulation. Contrary to the concept and mandate in 2009 and 2010 to distribute 50% of OHIM's renewal fees, the financial support will be realized by grants calculated on the basis of OHIM's revenue. The system and the level of the support are subject of the final negotiations between the Council and the Parliament. What about the measures that support the coexistence between the community and the trademark, the national trademark systems? And what about measures that make the directive more consistent with the regulation? Let me start with the consistency. More consistency between directive and regulation requires a higher level of harmonization according to principles of the regulation. Harmonization measures of that kind in the reform package are, first of all, or take it as an example, an important example, mandatory rules in the directive for GIs, for geographical indications, as absolute and relative grounds for refusal. GIs as relative grounds for refusal will require amendments in many member states, such as in France and in Germany, where currently GIs cannot be invoked as earlier rights in opposition proceedings. The measures will also contain mandatory rules in the directive for an opposition procedure before the national offices. Next point, which was already mentioned by Mr. Archambeau, rules for classification of goods and services, and very important issue for the practice and the functioning of a trademark system. These rules for classification will be implemented according to the principles laid down by the European Court of Justice in the IP translator case. And last but not least, I would like to mention here in this context mandatory provisions in the directive for the protection of collective marks. These are all measures that make the national systems more consistent with the CTM system. Which amendments or measures will support the coexistence between the community trademark system and the national systems? Of course, the higher level of harmonization in law and practice and the financial support for the member states will foster the national systems. A few words in this context to the genuine use issue. The genuine use issue was heavily discussed as a main feature for the coexistence at the beginning of the debate on the trademark reform in 2007. It was explicitly addressed in the 2007 Council conclusions as a topic for the study. Accordingly, this issue was one of the questions raised by the Commission for the trademark study. What is this genuine use issue? It relates to the requirement of a genuine use in the union or in the community, provided by Article 15 of the regulation, and in particular to the territorial requirements for a use of a community trademark in order to maintain the rights in that mark after the end of the 5 years grace period. The Max Planck Institute proposed to leave Article 15 of the regulation unchanged, a legal rule according to which a community trademark must be used in more than one member state would not be in line with the supranational system of the community trademark. The Commission followed this proposal of the Max Planck Institute. Also, the European Parliament and the Council supported this approach. Meanwhile, the European Court of Justice has ruled in the Leno-American case on the genuine use issue. This judgment contains two important findings. First, for the assessment of genuine use in the community, within the meaning of Article 15, paragraph 1, the territorial borders of the member states should be disregarded. And second, the assessment whether the use is genuine must take into account all relevant facts and circumstances appropriate to determine that the use is liable to create or to maintain market share for the goods or services protected. This judgment has clarified the topic to some extent. The assessment of genuine use must have regard to all the facts and circumstances of the individual case. The trademark offices and courts have significant scope to assess these requirements. However, a practice that would accept the use of a trademark for consumer products in a very small part of the Union, whereas the market extends to the whole European Union, appears not to be in line with the requirement to create a market share on the market of the European Union. Thus, the genuine use requirement applied in accordance with the interpretation of the European Court of Justice can affect the coexistence and foster the national systems, since CTMs cannot always be maintained by using a mark in just one member state or even a part of it. Just a few words to a Commission proposal to apply the absolute grounds for refusal in Article 4, paragraph 2. The Commission proposed an application of these absolute grounds for refusal which do not apply in the member state where the trademark has been filed, but in other member states. This proposal has clearly been rejected by the Parliament and by the Council. That is important for the national systems, as they can continue to provide protection in cases where protection at the European Union level is not available. The national systems allow protection when absolute or relative grounds for refusal only apply in other member states, whereas protection at the Union level is in these cases not available. This function of the national systems strengthens these systems and supports the coexistence as well. And last, the fee issue. The fees payable to OHIM are considered to be an important element of the coexistence. Council and Parliament agreed that the fee structure should be directly fixed in the regulation. The fee amounts will therefore be set in an annex to this regulation. Council and Parliament further agree on the general principle that the fees should be fixed at a level so as to ensure that the OHIM budget is balanced. In addition, the Council has proposed a clause in the recitals that the fees level should ensure the coexistence between the community trademark system and the national systems and take into account the size of the market covered by the European Union trademark. This explicit reference to the coexistence as an element for fixing the fee level would also, of course, foster the coexistence. It seems to be still under discussion between the institutions. So the initial question, if the European trademark reform meets the expectations, can be, or I would answer to this question with a clear yes, it does. Whatever the outcome of the debate on the remaining political issues will be, the European trademark reform will achieve the main reform objectives as they were defined in the May 2010 conclusions. Thank you for your attention. Thank you very much.
Thank you, Mr. Knaak, for sharing with us your views, and actually for us as a European Council presiding country negotiating at the moment trademark package with European Parliament, it's not only important to finish all those negotiations and finalize the text of directive and regulation, but also meet some expectations of the users and also of the offices. Thanks, Mr. Knaak. The next speaker in our list is Mrs. Jutta Figge. She is representing German Federal Ministry of Justice, more precisely Directorate General for Commercial and Economic Law. She is the head of Trademark Division, and he has joined German Federal Ministry of Justice at the time when trademark reform was announced by Commission, and this has been the main subject of her work for the last 3 years. And actually, we were very happy when German Federal Ministry of Justice proposed to speak at this conference about certification marks. We do not have in our law certification marks, but there are some internal discussions about introducing them in our law because they really exist in the market. We all know green spoon, in Latvian zaļā karotīte, and the owners of those marks are trying in some way to protect it, to protect their marks using collective marks or applying for individual marks and licensing them. But now we will hear what is the view about certification marks in German Federal Ministry of Justice. Okay, please, Jutta.
Yes, thank you. And ladies and gentlemen, it's a great pleasure to be here in Riga today to talk to you as part of the Trademark and Design panel. Let me give you first the warmest greetings from Christoph Ernst, who's really sad that he can't be with us today, but he's felt ill, so that's the reason why. Our presentation will deal with the interesting subject of certification marks. Not fee, not budget, just some trademark issue. Within the framework of the EU trademark package, the European Commission presented an interesting proposal on this, which will, in all likelihood, lead to the introduction of a new category of trademark, the European certification mark. What that means and what consequences this will have for the national legal systems of member states is something I would like to examine in the course of my presentation. Ladies and gentlemen, all of us have already come into contact with certification marks and guarantee marks in the marketplace. By way of example, let me show you just a few seals of quality that are used in the same way as certification marks. I'm sure everyone here will recognize these symbols. The seal for fairly traded goods, the Fair Trade seal, the European Union's green organic logo for food, the MSC Marine Stewardship Council eco-label for fish from sustainable fisheries, the Trusted Shop sign for online shop operators, last but not least, the Geprüfte Sicherheit sign, which is at least familiar to those of you who sell goods, consumer products on the German market. The use of individual seals is not always subject to uniform criteria, and this is also true for the legal provisions they are based on. A small number of seals are regulated in detail by law, such as the EU organic logo. However, the quality criteria and granting conditions of most other seals are based on private law requirements set by the seal providers. In general, certification marks are trademarks that serve to communicate to the consumer a particular quality or nature, which brings us to the fundamental difference between certification marks and conventional trademarks. With conventional trademarks, the main focus lies on the so-called origin function as the primary function. This origin function serves to distinguish the products of a particular company from the products of other companies. However, in the case of certification marks, trademarks, yeah. However, in the case of certification marks, the main focus lies on the quality or guarantee function. The primary purpose of affixing this mark to a product is to guarantee a certain characteristic or quality of the product. In other words, the manufacturer doesn't use the sign to indicate the commercial origin of its goods, but to make a factual statement regarding their quality. For example, to convey the fact that the goods he is offering have been tested for safety by an independent body. This takes us directly to the next question, namely, what legal framework conditions are currently in place for certification marks? First, the Community Trademark Regulation doesn't contain any specific provision for certification marks at European level. However, a few provisions are contained in the current Trademark Directive. According to Article 1 and 15, the Trademark Directive also applies to certification marks if the law of the Member States provide for registration of certification marks. If you look at the legal system of the Member States, the picture is uneven. More than half of the European Member States don't provide for the legal instrument of the certification marks in their national systems, whereas other Member States have issued provisions for this type. Germany, and as I have learned also Latvia, belong to the Member States that haven't regulated certification marks at the national level. The category certification mark doesn't exist. In Germany, trademarks that make binding statements about the quality of a product are usually protected as collective marks or individual marks, which are then used in the same way as certification marks. Ladies and gentlemen, let us now take a look at the future legal situation. The European Commission has presented a proposal that has so far met with no substantial resistance from either the Council or the European Parliament. There's therefore a strong likelihood that a European certification mark will be introduced at EU level. Yeah, there it is. Main aspects of the European certification mark are that the proprietor of the certification mark himself is not permitted to supply any goods falling under the certification, and that he must draw up regulations governing use of the mark, which state the certified characteristic as well as the body responsible for testing and supervision. This is intended to prevent a conflict of interest between the trademark proprietor and the trademark users, since the trademark proprietor is, of course, responsible for monitoring whether the certified criteria are met. As in the past, the new trademark directive expressly leaves this up to the member states to decide whether or not to introduce the certification mark. However, introduction of a community certification mark could mean that national legislators may have to re-examine the question of whether such an instrument should also be introduced at national level. At least, it would pose this question for the member states that so far don't provide for this type of mark in their legal systems. The member states that already have such provisions in place will presumably have to examine whether it is necessary to adapt them to European legislation. Ladies and gentlemen, before continuing, I would like to say that I personally think that introducing the certification mark into German national trademark law makes sense. This is, above all, borne out by the need for balanced coexistence of the national trademark systems and the community trademark system. National trademark law should be just as open to new categories of trademark as community trademark law is, and vice versa. If it's possible for users at the EU level to obtain accurately fitting protection for seals of quality, this should also be possible at the national level. This, of course, raises further questions. Permit me at this point to briefly touch on just one of these questions. The question concerns the relation to existing collective and individual marks which have up to now been used as certification marks. Here the question arises whether a possibility should be created for these marks to be converted into certification marks. In such a case, a relevant provision would have to be introduced into national trademark legislation. Ladies and gentlemen, this is naturally not the only question that arises in connection with the introduction of the certification mark into national law. Our first step, therefore, will be to seek a dialogue with the interested parties in order to identify where there is a need for the EU legal instrument, to find out how we can best serve this need in the drafting process. There is, needless to say, still a fair amount of work to do here. The whole certification mark issue shows that the EU trademark package contains many innovative approaches for both procedural and substantive trademark law and the institutional framework. Allow me to follow up on what the previous speakers have said and briefly look at the current situation from the perspective of a member state. For Germany, the European trademark system has been an unprecedented success story. The system works. And with this, I mean the system as a whole. This includes the community trademark and the national trademarks of member states in equal measure. By means of the community trademark regulation and the trademark directive, we have successfully created a coherent and harmonious system in Europe, which offers trademark users protective rights suited to their various and different fields of activity. The system's success is based not only on the high number of trademark applicants and the innovative economy, but also on the constructive cooperation between OHIM and the national trademark offices. Germany, like all other member states, has a keen interest in making sure that the system continues to operate successfully, as this cooperation is the key to success in ensuring that registered trademarks provide attractive and effective protection for the users of the rights conferred by them. All in all, there's therefore no need for the system to undergo a major legislative overhaul. Rather, the trademark package should concentrate on optimizing specific areas. A core objective is to achieve further convergence among national systems, as well as between national systems and the community trademark. Here it is above all important to have the right balance between the coexisting trademark systems. Both rights, national trademarks and their community equivalent, are indispensable legal instruments in a European single market. Both types of trademark have their advantages and disadvantages for users. Both types of trademarks are needed for the single market. I believe that the strength of the existing European trademark system lies in its very diversity. The national trademark systems, combined with the community trademark system, are decisive in giving the European market its competitive edge. This provides small, medium-sized, and large enterprises with the trademarks best suited for safeguarding their business performance in their particular area of activity. All of us in Europe benefit from strong national trademarks and strong community trademarks. Ladies and gentlemen, I would like to conclude with a brief summary of the main points. Certification marks are not new territory for Europe. What is new is the idea of regulating them at EU level as a separate category of trademark. Member states that have so far made no use of the optional provisions in the Trademark Directive will now have to examine whether it might make sense to introduce the certification mark at national level. But, first of all, of course, we will have to wait for the final outcome of the legislative process at European level. And whatever the outcome, we are certainly open to the idea of introducing the certification mark. This type of mark has the potential to become a further ingredient in the ongoing success story of European trademark law. To conclude then, certification marks have an important guarantee function. But the concept of a guarantee doesn't just apply to certification marks. Ultimately, the EU trademark package itself should act as a guarantee that the user will be ensured the best possible framework conditions, both at the European and national level. We are working on this in Brussels and Strasbourg, and we are definitely on the right path. Thank you for your attention.
Thank you, Jutta, for sharing us your view about certification marks and also your view about trademark reform. We will cross our fingers and try to do our best to finish before Easter, as Commission said. The next session, the next speaker in our session will represent a Latvian company, Helico Aerospace Industries, Mr. Agris Tipurs. He's here. I'm happy. Short introduction. It will be not so much about trademarks and designs. It will be more about how one can transfer his hobby to her business. Mr. Agris Tipurs is a founder and COO of the, what was the name of the company? Go
with the short one, AirDog.
AirDog, yeah. And when we asked him, do you have some registered trademark or some registered designs? I have, yes, we have registered community trademark. But his presentation will be, as I said, how to transfer their hobby to the business, and actually it's a little bit connected to what Commission said, what Mrs. Jorna said before coffee break. It's about new technologies, it's about robots, it is about what one small Latvian company can do. Enjoy.
Yes, hello. Thanks for the warm welcome. This is a slightly different sort of audience we usually speak to. Usually the guys we speak to are dressed in hoodies and sneakers. Startups, young companies trying to make a fortune out of their business idea. And that's actually what we are these days, even though we are, already a well-known brand in the consumer space. We are still a startup, and we are still looking to make the business into something really valuable. So I'll be talking about, the title is Trademarks That Matter, but it's really a story behind AirDog and why we think that AirDog is today a brand that is worth protecting and worth spending those dollars on legal fees to actually get the trademark registered. So the odd thing about AirDog, I believe, is that despite the fact that we are really among the best known brands in the consumer drone space for today, we still need to ship a single unit. So we are actually in a pre-market position, even though we have generated in sales, in pre-orders actually almost $2 million. But we still haven't shipped a single unit, and that might sound odd, but that's how much internet and social networks these days have changed and transferred the way businesses are built. Just to give you an idea what AirDog is about, somebody said that a video speaks 1,000 words, so a short video just about the product, how it works, what it actually is. So it's actually that simple, but as with many things, especially in the space of technology, things that look simple are hard in execution. And AirDog, of course, is a very challenging technology, looking to do a very simple thing, just to follow you and capture your activity on a video while you are doing your favorite sports. So what do we try to do with the product? We actually try to significantly expand the current consumer base of drone technology. So today drones are bought by people that are either RC piloting enthusiasts, do-it-yourself enthusiasts, or amateurs photographers. We were looking to place the product in hands of those that actually don't care about the drone itself, that care about the content, that want to capture their activity in sports without any third-party assistance, without limiting their performance, and have a great video to share with their friends. And that's what we started with. And when we started the company, we realized that hardware is hard to do. We need lots of money. We need to raise lots of investment dollars in order to make it happen. For a young company out of Baltics, without actually having an experience in a consumer electronics space, it was a big ask for us. And investors, venture capitalists were not ready to fund the business just based upon a pure idea of us being really excited about what we want to do. So Kickstarter came handy for us as a team. So from day one, it was pretty much, we very much realized that Kickstarter is the sort of platform that can help us take the business off the ground. So we invested our own money. We borrowed loads of capital from people that were ready to lend, just to get to that point where we have a team in place, a working prototype, an early prototype that, honestly saying, barely worked, but at that point, it was enough to launch a Kickstarter campaign. For those who are not aware of a Kickstarter, just shortly, Kickstarter is a crowdfunding platform. It's a platform used for young companies looking to bring their products to a market, but that need actually funding. So what they do, they launch a campaign on a page. They speak about the product that they are building and hoping that people will get behind it and will actually spend money on a product that doesn't yet exist. So that's what we did. We launched a Kickstarter campaign. We told about the idea to the world. We asked for $1,200 per unit. If you think about it, it's completely insane. I still cannot believe that people actually pledged $1,200 per unit for a product that didn't exist back then. It was just a plain idea that they believed in a team they knew nothing about coming out of Eastern Europe. But we did amazingly well. We actually raised over $1 million, significantly over $1 million, as you can see there, throughout a course of 30 days. So it was a 30 days long campaign. And we got that money we actually needed to really give it a go. And for us, of course, it was also very important to test the market product fit. Because it was our assumption that people need a product of that sort, but we were not, of course, sure. There was no other way how to prove it. So this was actually how we did it. This was something we went back with to investors, saying that, hey guys, you didn't believe in a team of ours, but this is the campaign we did. These are the dollars we have raised. And this is the evidence that people actually need a product. Can you imagine there were over 1,000 people out there willing to even pay for it, not only vote for wanting to have a product. So the Kickstarter, of course, was very, very important for us, and it really helped to create that early consumer base, that group of very passionate people that are still behind the company, that are still supporting our efforts. But again, I'm going back to those venture capitalists because they are a good indication of how investment dollars are raised in a space. So when we went back to them saying that, hey guys, we have a great Kickstarter campaign, we know what we are doing, they still told us, yeah, I know, at this point it looks amazing, but you just need to prove that you can really build a consumer product, a product that you can actually ship, and you need to prove that you can compete with all the other companies out there in the space that have raised 50, 100 millions of dollars and have turnover of hundreds of millions of dollars. So we thought, okay, what is the next step? How we will do that? And CES and our appearance at Consumer Electronics Show in Vegas was how we decided to tackle the problem. Consumer Electronics Show is the biggest, the largest show in the world for consumer electronics. Happens in Vegas. 10,000 media people go over there. Thousands of companies participating. We were among those few. So CES for us was important to demonstrate that in 6 months we can get from an early prototype to a consumer product. And we really wanted to differentiate AirDog from all the other products out there in this space. And again, we were fortunate enough to be extremely successful there. We actually got the award for the best robot or drone at CES. So we actually beat all the competitors that were participating in the exhibition. We were running loads of live demos for the product out there in the desert, and everybody was loving the product, loving to an extent that they decided that the award should be given to a company that is still at a pre-market stage, and that helped. And today, 2 months after the show, we have finally managed to convince those evil venture capitalists, and they have agreed to invest a bit of money into the company. So about the KPIs behind our journey up to this point. So there are almost 500,000 visitors for the web page of ours up to this point. So 500,000 unique visitors have actually taken their interest and looked at what we are having and what we are telling about ourselves on our web page. Our most popular Facebook posts have a reach of 200,000 Facebook users. So how do you generate a reach for your Facebook posts? When people like your posts, when people are sharing your posts, those posts are shown to a larger community. So the better posts you do, the larger group of community and supporters you have, the better those posts are doing. So today, in case we do a really good post on our Facebook page, we can count on 200,000 people actually seeing it. ERDA has been covered by media outlets like CNBC, CNN, Bloomberg, Forbes, pretty much you name it these days. Takeaways. Just to relate my speech a bit to the subject of this conference. So businesses make brands worth a fortune, not the other way around. And I think this is important to realize it, because often, especially in a startup community space, people for some reason think that it takes great graphics and great brand strategy to make a business worth more. But actually, businesses work brands worth a fortune, and businesses are the ones which make people love the brands. So it's what's behind the brand. It's those values that the company is able to execute upon, and that is what this slide is pretty much saying, that execution matters. There's nothing more important for a consumer oriented company than loyal consumer base. So that's what we all are after, and only in case you are able to get to the point where you have a loyal consumer base, it becomes worthwhile to start caring about your brand and about protection of your trademark. And we think that ERDAG is currently at a stage where we should be starting to care about how well our brand, our trademark is protected, and that's why we have actually, yes, registered the trademark, and of course there's also IP for the intellectual property behind the company. For those who didn't notice that A letter in our logo actually looks like a dog, this might help. Thank you. That's about it. That was what I was willing to share with you. Thanks for the attention.
Okay. Thanks to Agris for sharing us experience with how to start a new business. Now we have time to ask questions. Does somebody wants to ask something to someone? Sure. Yeah. Do we?
Okay, I have a question. I have a question to Mr. Tipurs. As you mentioned, there are many drones around the world, and you have to compete with all of them. Have you concerned with some patents concerning drones? As I know, you don't have any patent. Am I right?
Not really.
And okay. Please share your views on patents and your business.
So at this stage, we have filed the provisional patent for our obstacle avoidance solution, which is something we shared publicly with everyone during the Kickstarter campaign. So before we actually shared, we made sure we have filed the provisional application. But as regards to all the other stuff that is potentially patentable, we just had to raise those venture capital dollars in order to afford it. It's expensive for a global product, for a sort of a scale that we are looking to protect it in. And it'll be something we will be actively doing during March and April, and hopefully by the end of April we have filed provisional patent applications for the stuff we think is worth protecting. So it is certainly important for us, but even more important than that, I think brands that build loyal consumer base, we think that that's even more important than protecting your IP, because these days it is a huge challenge. You guys probably know it a lot better than I do, but what I see in businesses is that those brands that really have that loyal consumer base do extremely well, despite the fact that there are many doing something probably very similar, and some probably even stealing or not obeying to those rules of IP rights.
Okay, one more question. Yeah.
I also would have a question.
But you should speak in the micro because interpreters need to interpret. Okay.
Where do you see the next 12 months? I mean, what will happen now, and how much you are proposing a global market, global product? How much will be in Europe of your next steps?
Thanks. So for us, the primary market is North America, because the product focus is action sports, and action sports in North America is a huge market, and it's an amazing opportunity for us. That's why we initially went for the traction and attention in North America. So in the next 12 months, we are looking to actually ship the first units. So the plan is to ship in Q2 this year the first unit of the first batch of air dogs, and hopefully in next 12 months we manage to launch the product into retail distribution as well. Primary North America, a few markets in Europe, and Australia, of course, is also another very, very interesting market for us, with surfing being huge out there.
And you produce here?
Yeah, our contract manufacturer is Latvia-based.
More questions, maybe about European Trademark Design Network certification marks or AirDoc? Other? Yeah.
Yeah, again for the AirDoc. One thing I learned from your presentation is that you need a unique selling point. There are many drones, but yours is the one that follows you, that makes pictures of you. And I think you need to look at the complete IP system, not just the AirDog, because other people might easily follow this idea. And I think you need maybe patents, you need other things. So model maybe is protectable. It shows, I think, SMEs can do very well if they distinguish themselves clearly from the competition and have a unique selling point that people believe in. And I think the IP system is the proper way then to look at how can you keep that idea for yourself without others copying it.
Is there a particular question I hear? Because I agree with you 100%. There's nothing more I would even add to it. But just to comment a bit, yes, I do believe that the unique selling point has made us successful because we have been extremely focused on delivering the message over the about the product. We are specifically addressing those in action sports, and we are specifically solving that problem of you being able to capture your activity without any third-party assistance. So we've been very, very, very narrowly focused. As regards to IP and protecting the idea behind the product, it's simple on a surface. When it comes down to technology, it's a lot more complicated than that. We actually do specific algorithms tailored for specifics across different disciplines in sports. So the drone will actually act differently in kiteboard than it will in a skateboard, for example. So, and that's something that's not visible on a surface, and that's something that we are actually looking to protect, and that's where we think our secret sauce is in. It's in the software, it's in the fact that it's specifically tailored for different usage patterns across sport disciplines.
Thank you. More questions? No more questions. Then once more, I would like to thank all the speakers. Mr. Archambeau, thank you. Okay. Mr. Knaak, thank you very much. Thank you. Then Ms. Jutta Figge, thank you. And also thank you to Okay, and now I should announce that now we have a lunch break. The lunch will be served in the first floor. It's downstairs and that part of the building. And the next session then will start after lunch break at 2:30, again in this room back. Have a nice lunch.